Our special guest for today is an arbitrator and litigator, a frequent speaker and author, partner at the Global Dispute Team at Jones Day, and a pioneer in the movement for a new generation of dispute resolution practitioners, or dispute managers, as he calls them. Ladies and gentlemen, please join me in welcoming, with a big honor for us today here, Johannes Willheim.
I was here exactly 1 year ago, delivering a speech on my vision of what I call disputes management. And I felt sort of the vibrations and the awes in the room, and I was getting very excited, and I felt everybody understands me, and they understand my vision, and they share my vision. I go down, people congratulate me, and I think it was you, Tom, but I'm not sure. Maybe I'm just blaming you, but you're nodding, so it was you. And you said, hey, that was a great speech, great vision, but I'm sort of missing the granularity. I mean, what exactly do you mean is the School of Disputes Management all about? And I realized, great vision, no substance. I completely failed of sort of explaining what my vision is all about. So I've had a year, I've been thinking about it, and reflecting about it, I thought maybe the best way to deal with it is to come up with another vision. And so, Tom, we can do the same thing one more time. So my vision is the vision of you guys, not you, the assessors, but the new generation of dispute professionals. So what I will do now is I will explain my vision of a school of dispute management through my vision of the future dispute professionals. And I will do so by starting with 3 predictions. And then I will elaborate on the 3 predictions, and Tom, let's see if there will be some granularity in this. Prediction number 1 for the future of dispute professionals is there will be 2 types. There will be those, thank you, Claudia, who I call dispute managers. And then there will be the others who I call the experts, or even process experts. And I will explain. Prediction number 2, dispute managers will not be like me, and I have to face this fact every day. I'm old school, I'm no longer the new generation, although I would want to be. Will no longer be trained like me as a lawyer, but they will be trained in multiple disciplines, and the focus of their training will not only be on academic training, as I have been trained, but it will be a lot of skilled training, and it will be continued training a lifetime long. And the third prediction is dispute professionals of the future will be supported, but don't be afraid, not replaced by technology. And I will explain all of the 3 key predictions, how I get to there. Now, my first attempt to define and explain what I really mean about dispute management. So, I think I began last year, and I ended there, I know. So I will try to take it a little bit further this year by explaining sort of how the work of disputes professionals has worked traditionally. There's been a problem, a dispute. People tried to solve it consensually. They failed, so they rely on force. But force in itself is not very pleasant. You hate to beat yourself up, so you delegate the force to disputes professionals. And at the time, and still today, it's mostly lawyers. So you delegate your dispute to lawyers, and you have them sort it out. Now the problem with that is that our legal system, although it's multifaceted and it tries to sort of catch all problems of the world and life, it's limited. It provides very limited ways of resolving a dispute. You'll be granted a payment claim. The payment claim can be enforced. You get a cease and desist order, or the cease and desist order is dismissed. You can exclude a shareholder. But ultimately, all these things often don't serve to really resolve the core problem. They're just patchwork solutions. But that's how it was. And the thinking of those in charge of resolving a dispute was, how do I get from, let's say, a derogatory statement in public to a cease and desist order published in the media and a payment penalty which is enforceable? And you think, okay, I have to present the facts, I have to present witnesses, I have to have a legal case or whatever, and ultimately you come out with that. So the process was not in the brain beginning of, why am I having this problem? Where do I want to go with this problem? How do I want to solve this problem? And how is it best solved? And there's nobody, and I think I said this last year as well, who actually teaches us the skills necessary to ask the questions, and after having asked the questions, to actually come to solutions. And that is what I call a paradigm shift from sort of a process-based approach, legal proceedings, or, sorry guys, mediation is not that innovative, as we heard from Elise. It's been around for a while. Based on mediation, how do I go about mediating a dispute? But it's starting at the core, namely the dispute, and then it begins to sort of evolve through decision tools, and we'll talk about this in a second, to come to a solution, or not even a solution, because a solution may not even want, you may not even want to have a solution to a certain problem. I always give the example, disputes and litigation can be a strategy. You want to drive your competitor out. So all of us who talk about consensual dispute resolution, we are not the right guys if your strategy is to drive somebody out by litigation. We come there and say, why don't you sit together? What's your goal? Where do you want to go? It's not going to work this way, right? You want hardcore lawyers who litigate. Okay, so how do I envision this school of dispute management? What are sort of the main components of it? And again, Tom, I did my homework. I came up with, I think, 4. Let me see my notes. I came up with what I call the 4 pillars of dispute management. First pillar, old school, knowledge and skill, but a lot more extended knowledge than just legal knowledge. Multidisciplinary knowledge, psychology, forensics, economics, mathematics, all things we haven't studied in law school, but all things, if you want to be a leader in your field, you should start reading right now and start working on right now. Second one, analytical tools, and there's a variety of analytical tools. The case screening tools, which process is the best process to get there where I want to get. Arbitration, of course, the default, but if it's not arbitration, litigation, mediation, negotiation, whatever. But again, analytical tools. How do I make the decision? How do I decide which process is the best? Not, I have so many years of experience, I tell you this is the best way. And there's a very good organization out there in the United States. It's called the CPR, the Center for Conflict and Dispute Management or Resolution. Just Google it, and they have on their website something called toolkits, and you find things there like how to best find a neutral. How do I assess how I resolve my dispute? So that's what I mean with analytical tools. Very important analytical tools, decision making. I would love to lecture about this for hours, but you came here for a competition and not to hear me. And then pillar number 3, efficiency tools. Things which make our work easier. Electronic databases, research tools, e-discovery, all of that stuff. And 4th, The lawyers may not believe it, but I really call it a pillar because it is underdeveloped, although lawyers think differently. Communication skills. Real training of communication. To whom am I communicating what? And more importantly, what is this person going to do with this? All of those who have already worked in practice, in particular in law firms, like before filing of a big submission in arbitration or before a closing of a transaction, everybody gets spammed with 100 of emails. Sometimes people don't even change the re section in the email, but they expect everyone to read everything. It's like we don't even work with the basics of, what, to whom, and why, and what do I want from this person. So key pillar, communication, and believe it or not, that requires sort of thought and skill and teaching. Now, having laid out those 4 pillars, it is easy to see how technology comes in that. And I was this year at a conference in Zurich organized by Global Arbitration Review, GAR, and we spoke about our vision of how new technologies and artificial intelligence is going to intrude arbitration. And we spoke about the key fear of some, will actually technology replace us? And I was surprised. I was sitting on a panel with super professionals, and I felt like in the Stone Age. We spoke about things which are efficiency tools and which are standard. Case management tools provided by arbitral institutions, electronic filing, electronic sharing of documents, video conferencing, but all of that is a reality today. And for this generation, you don't even think about this anymore. Technology is everywhere in each pillar which I have outlined. It is there and it will clearly evolve. And the key question only will be, what is with this artificial intelligence? Will it really sort of replace the decision-making and judgment made by professionals? Now, the default opinion, if you ask people today, is judgment should never be delegated because ultimately it's us humans and we are unfallible. But if you look a little bit deeper into the subject, you will realize that actually human bias, racial, sexual, sociology, is a lot more problematic than what machines today can already sort out. So again, it's a reality today, and it will support us, making our life easier, helping us to make proper judgment calls and informed judgment calls, and not relying again on our little black box in our bellies or our brains. It's easy to see now, after I've outlined a little bit more, I hope with a little bit more degree of granularity, what I mean with the School of Dispute Management, how this ties into the 3 points or predictions I have said. We are here at the Economic University of Vienna, so management theory is something which is taught here all the time, and if you Google management theory, you will find 100,000 definitions. An Austrian, Peter Drucker, is a thought leader, or has been a thought leader on the subject. My definition of management is very easy. It is deliberate planning and implementation of a goal. So if we translate this into dispute management, it's deliberate planning and implementation on how you want to handle and maybe even resolve disputes. And then it's also easy to see what a dispute manager is. A dispute manager is a person who deliberately plans and implements strategies of how to handle disputes. And they will do this upon application of the tools in the 4 pillars, and a lot more to come and evolve. So this is the first type. The second type of disputes professionals are those who are in the process themselves. The attorneys, the arbitrators, the mediators, the negotiators, and of course there will be hybrids. Those who can manage and plan and implement and still work in the processes themselves. This is my third vision of the day. Working in an institution like this firm or any other firm, not being a litigator, an arbitrator, but foremost, a dispute consultant, a dispute manager, beginning to guide my clients from the problem they seem to see to how we're going to handle it and ultimately resolve it, or whatever the goal is. And we will do this not only by, okay, I can write you a legal letter, I can write you a memo, I can file a brief and get an injunction, but by going through the process of the pillars, analyzing, do it efficiently, communicating right, and ultimately implementing the strategy so developed. That's my vision of who I want to be and who I will be. I think it's very clear how the second prediction comes in. It's not going to be enough to study law. You need to study all of this. Law schools will change to dispute management schools, or at least have master programs or certified dispute manager programs. And people will learn exactly this. They will learn these tools, apply these tools, and of course, hopefully further develop these tools. And we will do all this, third prediction, greatly supported by technology, but not replaced by technology. Now, what does that all mean for you? It means for us, we're sort of limited in what we can do because we learned to mediate, we studied law, but for you guys, it means an exciting future. It means an exciting future because you will be not trapped 24 hours in a little law office going through documents, but you will use e-discovery or other tools help you to go through these documents, and you will do what you have really learned. You will exercise judgment, you will consult, and you will be a leader. I really love the IBA video. Inspiring. I see myself like this. I love sort of the parts with no paper. The parts with the paper scare me. They remind me of my reality, but that's your future, that's your vision. So it's super, super exciting. It also means that you will be so much more holistic than we all are. And the third prediction for you is you guys already have a head start because you recognized that doing mediation and practicing your skills is equally important, and you do this in the best environment. It's super exciting. I wish I was sitting on this side and not standing here. I would want to do it all again, and in particular in these times. So enjoy your competition and become inspired and thoughtful dispute professionals of the future. Thank you very much.